To another session with Accent Realty, where we talk about property issues and allied matters. And I am your humble host, Benson Okeziowosu, Esquire. So we are here once again to bring you another relatable and recurrent property issue that occurs in the real estate industry. And the topic that, contains this message that is intended to be passed to you to this very moment is risks of buying mortgage properties, tips to avoid them. Now, I'm sure in previous sessions we must have discussed or talked about what a mortgage is, and it's simply a legal agreement involving two parties known as the mortgagor and the mortgagee, where the former, being the mortgagor, borrows a sum of money from the latter, known as the mortgagee, obviously at an interest rate, and to be repaid after a duration had elapsed. Now, what makes this form of this mortgage, because this is a form of loan agreement, to be honest. However, what makes this unique is that it's usually a transaction between one party who can either be a natural person like my humble self, or an artificial person like a business name, a company, and the other party, being the mortgagee, is usually and almost always the bank. So that's what makes a mortgage transaction, a mortgage arrangement rather, unique. So now another thing that makes a mortgage transaction unique is the fact that more often than not, if not all the time, the collateral in securing this loan must and always is a landed property, either your bare land or a raised structure, but it must always be a landed property. Now, the essence of today's session is to bring to you, like the topic says, risks associated with buying mortgage properties. Now, the idea, obviously, in your regular loan agreements, the normal thing that happens is that when you default in payment, your creditor is free to take up the collateral, sell it off to secure and satisfy his debt, and to remit the excess to you, being the debtor. However, that's freedom, that laxity is not always the case in a mortgage, because another unique feature of a mortgage transaction is the saying or the legal principle that a mortgage is always a mortgage and nothing but a mortgage, which simply means that irrespective of how long a mortgagor, that's the party who borrowed the loan from the bank, owes the money, that the mortgagor reserves the somewhat absolute right to redeem the mortgage. That the redeem means to pay back the loan sum, and to get back the collateral which he used to secure the loan, which is the landed property. However, we all know that most of what transpires usually goes outside what happens in paper. So, number one risk that is usually associated with buying a mortgage property is known as the default risk, the tendency for the borrower to default in paying. Now, to throw more light to each of these risks, I'm going to paint a scenario, at least for each risk, for better understanding. Now, in this case, like I said, default risk. If the borrower defaults on the mortgage payment, the property could be subject to foreclosure. Let me explain. Where party A, being the mortgagor, has borrowed a sum of money from the bank, being the mortgagee, and there is a third party, which is you, or who could be me, who intends to buy the mortgage property. Now, the mortgagor disclosed to you, as the one who wants to buy, that this said property is subject to a mortgage. And that mortgage there means an encumbrance. An encumbrance just generally means an impediment, a sort of claim to the title of the property to which the mortgage is ascribed on. So in that situation where if you go ahead to buy the said property, knowing fully well that it is under the mortgage, now where the risk involved in this transaction, in this scenario I just painted, is where the mortgagor defaults in paying the loan sum to the point where the property is foreclosed. Being that you, being the buyer, has bought that property and you are now the owner of that property, when the foreclosure is done, it will be done against that property which you now own. So to best avoid this, whenever you want to purchase a property, we have spoken so much on what due diligence connotes, and due diligence making the requisite search at the necessary places, being the courtroom, being the land registry, being the CAC, being the probate registry, as the case may be. In this case, land registry is obviously what we're talking about. The moment you see under the encumbrance, you see a mortgage, there are three options that are open to you in this scenario I just painted. Option one is you have to wait till the mortgagor has satisfied the loan sum and has facilitated the discharge of that mortgage. This way, you exclude yourself of any liability or any exemption or any issue that may arise in the initial transaction. Because, like from the scenario I painted, even upon buying the mortgage property, knowing fully well that it is such, you obviously did not have in mind, or at that point in time, it wasn't painted as a possibility that the mortgagor may default in paying the money involved. However, that has happened. So in order to avoid all that, number one, ensure that the mortgage is discharged before you purchase the said property. However, if you are so invested in buying that property that you cannot wait till the mortgagor discharges the loan or executes it and satisfy the loan sum, you can come to an arrangement with the mortgagor to buy the debt and take it up. So the mortgagee, upon default of the loan, would pursue the mortgage against you, being the new buyer, and not the initial mortgagor. That way you get to sort this out. But obviously, this option is usually when that property is a last option for you. It's something that you must purchase. However, if you are not hell-bent on getting that property, kindly wait till the mortgage property has been discharged from the mortgage. If you can't wait, you can either buy the debts away from the mortgagor and incur it onto yourself, or you go with the third option. The third option being meeting up with the mortgagor and the mortgagee and reaching an agreement where you buy the property from the mortgagor. However, you remit the loan owned by the mortgagor to the mortgagee, and then the excess will be remitted to the mortgagor. Let me explain. Now, in practice, it's usually advisable that if you want to take up a mortgage from a bank, that the security should be one that is higher than the sum that the loan gotten. For instance, you want to incur a loan of 90 million naira. You want to incur a loan of 90 million naira. Ensure that the collateral used, or rather, naturally, the collateral used should be one that should be, let's say, 100 million naira, with a 10 million naira difference. Now, if I come and buy the property, given that what you borrowed, let's say you borrowed 90 million naira from the bank, I will pay the bank that 90 million naira, while the excess being 10 million naira will be paid to you. The second risk that usually occurs in terms of buying mortgage properties, that there's a possibility that there will be a wrongful sale by the mortgagee Now, to further explain that, there are some instances. Now, the mortgagee, like I said earlier, mortgagees here are usually the banks. There are instances where banks, maybe when the, not maybe, usually when the mortgagor has defaulted in paying the loan sum upon expiration of the legal due date, they go ahead, or rather they think that that is enough for them to go ahead and sell off the said property. So in this, going off to sell off this property without anything more is regarded as a wrongful sale, because in a mortgage transaction there's something known as the power of sale. Before the mortgagee is able to sell any property, sell a mortgage property, the power of sale must first arise, and the said power of sale must be exercisable. Now, power of sale generally arises upon the expiration of legal due dates. Now, what do I mean by legal due dates? The mortgagor borrows 10 million naira to be paid back after 6 months. Now, power of sale arises the moment 6 months has elapsed and the mortgagor is unable to pay the said loan. However, that said power of sale must also become exercisable. And when does that become exercisable? Generally, upon the expiration of a legal due date, the mortgagee should, in written form, notify the mortgagor of the default that has arisen from non-payment of the said sum upon the expiration of the legal due date. And usually, the written notification to the mortgagor is usually contains a time frame within which it's a sort of allowance time, allowance to enable the mortgagor to, at least you've done two things. You've brought to the notice of the mortgagor that the time to repay the said sum has elapsed, and you are giving him ample time still to repay the said sum, still letting him know that upon the expiration of that ample time, if the payment is not made, you go ahead to sell the property. By the time you've done all this, power of sale must have arisen and become exercisable. So, as a buyer, what you need to do in this case is, if it is the bank that is offering the property for sale, the first thing that should come to your mind is that it should, I'm not going to say it's always a mortgage property, because obviously banks too own assets, they own properties. However, for the sake of being safe, always presume that that property in question is a mortgage property which they desire to sell. Now, the tip to avoid the risk of wrongful sale, because so far as if that case is taken to court and the court finds that in as much as the power of sale had arisen but it was not exercisable, the court will set aside the sale. In other words, you as the buyer who bought that property from a wrongful sale, you will lose the property. So the best thing to do is inquire whether if it's a mortgage property. If confirmed that it is a mortgage property, the next thing to do would be to ask and inquire the circumstances within which the bank acquired the said power, because obviously they will tell you that they have the power to sell it. But however, like I have said, there is something known as power of sale arisen and power of sale being exercisable. So the best thing to do is ask. The next tip would be to conduct your due diligence. Now, the due diligence in this case would be to ask for the said mortgage agreement and read through it to see when the legal due date passed, and inquire from the bank whether they made any notification of default to the mortgagor. Now, where this was not done, courtesy demands, knowing fully well that you are aware that power of sale must arise and must be exercisable, facilitate the bank to make the said written notification to the mortgagor to let him know of the defaults and so on and so forth, like I've previously said. Another option would be to basically reach out to the mortgagor and still go ahead to exercise the other tips that I gave for the first risk, and which are: number one, buying having a form of arrangement that assigns the debt to you, or buying the said property from the mortgagor, however remitting the sum owed to the mortgagee while remitting the excess to the mortgagor. Now, the third risk involved is known as the absence of a deed of discharge or deed of release. Now, this is not much of a problem. However, in law, or even generally, there's a basic saying that it is better to be safe than sorry, and that prevention is better than cure. Now, it is trite that the very step that puts an end to a mortgage transaction is the execution of a document known as deed of release or deed of discharge. Now, where the mortgagor has been able or has paid every sum owed, and including the interest to the mortgagee is required to exercise what is known as a deed of mortgage, execute rather, a deed of mortgage or a deed of release in favor of the mortgage, which the mortgagor would also execute and then take to the land registry, where it will be officially noted that this mortgage has been discharged, and which will remove the encumbrance. Now, I say that this is not much of a problem because as the mortgagor, if in this instance you buy the said property from the mortgagor, knowing that, okay, the said sum has been paid, however, this document has not been exercised yet, ordinarily this wouldn't be a problem at the first instance. However, the fact that the deed of release and the deed of discharge is yet to be exercised, it will always remain on your document at the land registry that there is a mortgage on this said property. It will remain an encumbrance. So, you being the buyer, the moment you want to sell, at that point you become a seller and you're looking for a buyer who goes to the land registry to make and conduct due diligence, only to see that there's an encumbrance on it, being the mortgage. That can discourage him from wanting to buy the said property. So the tip here is just to ensure that in as much as the mortgagor has paid the money completely, both principal and interest, to the mortgagee rather, ensure that you facilitate the execution of the deed of release or the deed of discharge, so that all things will be done in accordance with the law. Now, the fourth and not the least risk involved in purchasing a mortgage property is purchasing a grossly undervalued property. Whether mortgage property or not, the moment any property is so undervalued that it becomes ridiculous, that alone should be a point of query. For instance, you see a property at Banana Island being sold at 5 million naira. Oh, okay, 5 million naira is even too much. Let me say 2 million naira, and you jump on it. The fact alone that, one, it's Banana Island we're talking about here, and the property is being sold at 5 million naira, that is gross undervaluation. So the moment you see a property that is grossly undervalued, please, that should be a point of query. The tip here, and the best option in this case, will be to simply avoid the said property. Now, ordinarily, I know that the law does not necessarily require that a property should be sold at the best price. However, it should be sold at a fair market value. It should be sold at a price that would not seem ridiculous to the reasonable man, to the ordinary man. So the moment even it will be better if the property was overpriced than undervalued. However, it is better that everything is done the way it's meant to be done. So that's it for today. The risks, as I mentioned, number one, default risk, the tendency that the mortgagor would default in paying the loan sum. Number two, wrongful sale of the mortgage property while the property is still under the mortgage. Number three, the absence of deed of discharge or deed of release. And number four, purchasing a grossly undervalued property. Kindly take notice of each of these risks and the options and the tips on how to avoid them, like I've earlier mentioned. Thank you so much for your time. My name remains Benson Okezie. See you next.